This is Bloomberg Law with June Grasso from Bloomberg Radio.
This is Liberation Day in D.C., and we're going to take our capital back. We're taking it back.
On Monday, President Trump announced that he would take federal control of Washington, D.C.'s police department, citing what he called out-of-control crime to declare a public safety emergency.
This city will no longer be a sanctuary for illegal alien criminals. We will have full, seamless, integrated cooperation at all levels of law enforcement, and we'll deploy officers across the district with an overwhelming presence. You'll have more police, and you'll be so happy.
Well, D.C. Mayor Muriel Bowser didn't seem so happy. She said violent crime in the capital was at a 30-year low, but that the president's authority is pretty broad under D.C.'s Home Rule Act.
The Home Rule Charter requires the mayor to provide the services of MPD during special conditions of an emergency, and we will follow the law. Though there's a question about the subjectivity of that declaration.
But 3 days later, tensions flared when the mayor and D.C.'s Attorney General rejected an order from U.S. Attorney General Pam Bondi that would have stripped the Metropolitan Police Department's chief of her authority and placed the agency under federal control. And on Friday morning, D.C. Attorney General Brian Schwab sued the Trump administration, saying the attempted takeover of the city's police force was illegal.
And the Home Rule Charter and the Home Rule Act is very clear with respect to when the president can request limited services of MPD, limited by time, limited by emergency circumstances, and limited for federal purposes. And in all cases, those services must be requested to the mayor to be provided by the chief of police, not a hostile takeover of our police.
By Friday afternoon, both sides were in court for a hearing on D.C.'s request for a temporary restraining order to avoid sidelining D.C.'s police chief. My guest is former federal prosecutor Mary McCord, a professor at Georgetown Law. It seemed like Mayor Bowser was grudgingly complying with the federalizing of the D.C. police force until this order from the U.S. Attorney General naming the head of the DEA Emergency Police Commissioner of D.C.
Well, I mean, certainly even before the new order from the Attorney General, there were, I think, a lot of problems with the declaration of an emergency in terms of just not really having a factual basis. But the D.C. Attorney General had decided, obviously, not to sue based on that. And I think you're right that the triggering event was this order from Attorney General Bondi that basically really did take over the Metropolitan Police Department. It appointed Terry Cole, the DEA commissioner, as the commissioner to assume all of the powers and duties of the D.C. police chief, required that anything the D.C. police chief or the mayor or the commanders of police wanted to do had to get approval from Commissioner Cole before doing it. And then it actually rescinded various police executive orders and general orders. And so that really is a takeover. And that's what prompted D.C. Attorney General Brian Schwab to come in with the complaint.
In the lawsuit, D.C. alleged that Trump doesn't have the authority to take control over the police force, and he can only require the mayor to offer assistance from the police in certain emergency circumstances. Tell us more about the suit.
Well, I mean, it's really the D.C. Attorney General saying you got to comply with the law. And the law that President Trump invoked, that's part of the Home Rule Act that gave the District of Columbia, starting in 1973, the authority to, elect its own mayor and elect a D.C. council and enact legislation for the city and to have its own police chief and its own police force. But that Home Rule Act statutory provision that the president relied on doesn't say anything about taking over the Metropolitan Police Department. It says that whenever the president determines that special conditions of an emergency nature exist, which require the use of the Metropolitan Police Force for federal purposes, he may direct the mayor to provide him, and the mayor shall provide such services of the Metropolitan Police Force as the president may deem necessary and appropriate. And that is also time limited, no more than 30 days. So what the D.C. Attorney General is saying is There's nothing about that language that says that the president can actually appoint someone to completely take over the entire Metropolitan Police Department, rescind general orders, and require all activity to go through him. What this is saying is that the president can require the mayor to provide services of MPD. So if you think about it, let's assume there's some sort of assault on a federal building that houses a federal agency, protesters rioting, throwing rocks at the building and maybe lighting fires, what have you. You can imagine the president saying, we have a state of emergency. I don't have enough federal agents to protect this federal property. I'm going to invoke this provision and require the mayor to provide Metropolitan Police Department officers to go and help protect this building and quell the disturbance and the criminal activity there. That's like requesting services, and services must be provided. And I would just say, as a footnote, having been a prosecutor in D.C. for 20 years and lived in this area for 35 years, a president would never need to invoke this in order to get that kind of assistance from the Metropolitan Police Department if there was a real emergency, because the Metropolitan Police Department and federal law enforcement work together all the time. They have all kinds of task forces. They have mutual assistance agreements. And if you had a real emergency, MPD would be going to help. There was a real emergency at the Capitol on January 6th of 2021. And even though there are U.S. Capitol Police, which are federal police that protect the Capitol, D.C.'s Metropolitan Police Department went immediately to help with the emergency there. The president, of course, didn't ask for it, and didn't request it and didn't use this provision. But at any rate, this complaint is saying you can't just come in and take over the entire D.C. police.
And it seems like in these lawsuits against the Trump administration, there's almost always an allegation that the Administrative Procedure Act is being violated. What was it here?
In this case, what the president did is he delegated his authority to the Attorney General, Pam Bondi, who then is the one who put out this order actually effectuating or trying to effectuate this takeover. And so part of the causes of actions in the complaint are that is an administrative action taken by the head of an administrative agency that is contrary to law and arbitrary and capricious. So a number of different causes of actions in the complaint, but it really all comes down to there's just no authority to completely take over the police department.
Let's talk about the hearing over D.C.'s request for a temporary restraining order before Judge Anna Reyes. What were her main concerns?
So she agreed that Section 1 of Attorney General Bondi's order, this is the section by which Attorney General Bondi purported to basically give Mr. Cole all of the authorities of the chief of police and, complete direction and control really over the Metropolitan Police Department. She agreed that is inconsistent with the Home Rule Act. In terms of the other parts of the order, where Attorney General Bondi purported to rescind executive orders and general orders that operate within the police department, which are all immigration related. They have to do with not voluntarily cooperating with ICE enforcement unless it's something that's required by law. And there's very little that's actually required by law. So what the judge was focused on is, isn't it a problem to have these things be rescinded? Don't you need to put things in a framework of asking for services from the mayor and the mayor providing those services? What you seem to be trying to do, U.S. government, is you seem to be essentially bypassing the mayor and saying we're just taking over. And that can't be the way the statute works, because when Congress enacted the Home Rule Act, they considered a provision that would have just allowed the president to just take over the police department. And that was rejected because the members of Congress who were considering the Home Rule Act, they were doing so for the very purpose of there being local control, turning over local government, local policing to local control. And so it would be the antithesis of that to have the president actually take over the police department.
And what was the government's argument in support of this order from the U.S. Attorney General?
The government was trying to argue that really the request could simply be to the mayor that we require the services of MPD, and that then the president, pursuant to the Home Rule Act, has the discretion to ask for services as the president may deem necessary and appropriate. And in the view of the government, that kind of meant you can ask for anything and you can have a federal official actually controlling the police department. That's not where we ended up. we ended up in the judge taking a very long break to see if the parties could work something out between them, because she said, I'll issue a TRO if I have to, but if it's violated, that's going to be contempt of court. And I really think that this is the kind of thing that the parties should try to work out on their own.
And they did. Both sides agreed to leave the D.C. police chief in control of the department. The DEA chief is required to go through the mayor, and the mayor is still required to fulfill policing requests from the Trump administration. Thanks so much for joining me, Mary. That's Mary McCord, a professor at Georgetown Law. Coming up next on the Bloomberg Law Show, California and the Trump administration face off at a landmark federal trial over Trump's deployment of troops to Los Angeles in June. I'm June Grasso, and you're listening to Bloomberg. President Trump has repeatedly said that sending about 4,000 troops to Los Angeles in June saved the city.
And you watch crime stop, but you wouldn't have Los Angeles. It wouldn't be existent today. We would have had to cancel the Olympics if I let that go on.
But LA's mayor and California's governor have said that the troops weren't needed to handle the limited protests, and the presence of the military actually inflamed tensions.
The Marines that were never needed here, that never played a role in crowd control, they're not trained to do that. They're trained to kill the enemy on foreign lands. The enemy is not Angelenos.
But there's the bottom line. The police do policing. Military, it's for the battlefield.
After hearing testimony in a landmark trial in San Francisco this week, a federal judge will decide whether Trump's deployment of the National Guard and Marines to Los Angeles was legal. My guest is an expert in war powers and national security, Claire Finkelstein, a professor of law at the University of Pennsylvania. Claire, tell us about California's suit against the Trump administration.
There were two bases that the Trump administration has claimed for federalizing the California National Guard. And one is the protective power. This is claimed to be an inherent Article 2 power that the president can wield in order to protect federal assets. That means federal persons, federal buildings, and to say we're out there in order to protect anything federal. So that means ICE agents. And the claim is ICE agents couldn't do their jobs. There were also federal buildings under threat. And so we had to federalize the National Guard in order to protect federal assets. So that's number one. And then the other one is 10 U.S.C. 12406, which is a little used statute. The last time it was used was actually in the Nixon era to federalize the Guard on the grounds that there was a rebellion or that they could not otherwise get compliance with the law. And that was something that the Trump administration was claiming in this instance. The state of California challenged that and said, what's the basis for the federal government thinking that there was a rebellion? No signs of rebellion here, just some law enforcement issues, which we, the state of California, can handle. On top of it, California was saying this is a violation of the 10th Amendment. We, the state of California, California governor, California officials are in charge of law enforcement and police powers. And we are not asking you to come in. So that in general, when there is federalization to assist with policing, that is normally at the request of a governor. 12406 requires that troops be deployed through the governor, and that wasn't done. Governor Newsom wasn't even informed about the federalization of the National Guard before it occurred. That's the gist of their claim.
The trial judge Charles Breyer, who, by the way, is retired Justice Stephen Breyer's younger brother, said that the factual issue is, did the Marines and National Guard violate the Posse Comitatus Act? Tell us about that act from 1878.
So the Posse Comitatus says that federal troops normally cannot engage in law enforcement. So that is very different from when the governor is in control of the California National Guard under state's active duty status or Title 32, because in that case, there is an exception to Posse Comitatus when it is under control of state and local authorities. But when troops are federalized, the Posse Comitatus Act applies, and that is a criminal statute that says federal troops cannot engage in law enforcement activities. Now, the federal government says in this case, under the protective power and under 12406, number one, we were not engaged in law enforcement activities. The rules for the use of force that we gave to the troops, that's like their rules of engagement, except in domestic context, we call that rules for the use of force, did not involve, for example, making arrests. Troops were told that they could not make arrests specifically, and therefore they were not violating Posse Comitatus because they weren't involved in law enforcement activities. But California has said, in fact, you were involved in law enforcement activities and cited a number of instances, such as the ability to detain individuals waiting for law enforcement, such as LAPD, to show up. They maintain that that's a violation of Posse Comitatus.
And why does the administration say that Posse Comitatus doesn't even apply here?
The administration, in addition to everything else, rejects the claim that Posse Comitatus applies when the troops are deployed in their protective capacity, namely engaged in protection for federal assets. They also deny that it applies under 12406, and they say 12406 is like the Insurrection Act. Under the Insurrection Act, it's generally recognized that there is an exception to Posse Comitatus and that the president is allowed to deploy federal troops in a law enforcement capacity, but only because there is deemed to be a situation that is so serious that, in fact, there's a full-blown insurrection and there is no way to gain control over the region or that part of the country without having federal troops engage in law enforcement activity.
The testimony of one of the witnesses exposed the internal tensions over the deployment. Longtime military leader Major General Scott Sherman, who commanded the Guard troops in L.A., testified he'd never heard the word rebellion used to describe the situation in the city, and also that he had expressed resistance when immigration officials initially asked for military support.
So his testimony was important for a couple of reasons. The first reason is that he testified that he expressed reservations, and stronger than that he voiced opposition to this operation, and that he was rebuked by a senior Customs and Border Patrol official who questioned his loyalty to the nation, which is very surprising. It's very important that the military are able to express their concerns about the boundaries of the operations that they're being asked to undertake. And normally that would be given an awful lot of deference. When you have a senior military leader who is saying, this is not an operation that we should be undertaking, it's not appropriate for the military, you would expect an administration to be sensitive and respectful of that. But it also suggests that there was a sort of pecking order, and that was a concern about this operation to begin with, that Customs and Border Patrol was sort of calling the shot, and that the military was going to be placed in a subordinate position to Customs and Border Patrol. That's problematic from the standpoint of Posse Comitatus, since the military is not supposed to be subordinate to civilian law enforcement agents because it sort of turns them into law enforcement agents. So that's one reason this is problematic. Another reason his testimony was important is that he talks about what troops were told they were allowed to do and what they were not allowed to do. So though the administration has been very insistent that the orders to troops did not violate Posse Comitatus, his testimony suggested that they were allowed to turn military force to civilians if civilians were impeding federal operations such as ICE operations. Now, that might be what you would expect if they're there in their protective capacity, but it shows how tricky it is to have troops out there and to expect that they're not going to be involved in law enforcement activities, because it's very hard to draw the boundary there. If they're there in a protective capacity, they could very well end up having to engage in law enforcement activities. And typically, our troops are not trained for that. They don't know how to conduct arrests. They don't necessarily know how to intersect with civilians who are engaged in criminal activities. They don't know how to preserve a crime scene. They're not necessarily trained in that. And so, though our National Guard troops are excellent at what they do, crime control is not their beat. And this is presumably one of the reasons why General Sherman was concerned about this operation.
If all the troops were doing was guarding the ICE agents, would that still be a problem under posse comitatus?
Well, in theory, no. But as soon as you're guarding personnel, you could very easily stray into activity that implicates posse comitatus. So what if there's an attack on a federal officer and there's no one around but National Guard troops to engage in a detention or make that arrest? This is what happened in one incident involving a veteran who was trying to enter the Bureau of Veterans Affairs, and the Marines detained him, and he was detained for 2 hours, roughly. It was really a mistake. But because there were no LAPD present at the time, they viewed it necessary to hold him and detain him until law enforcement officers could show up. The question is whether or not there was a violation of posse comitatus just in the detention itself.
Trump has made threats against other cities.
That's going to serve as a beacon for New York, Chicago, Los Angeles, and other places all over the country. Our whole country is going to be so different and so great.
If President Trump tries to, for example, take over the New York police or the Chicago police, there he will not have the home rule advantage that he has in D.C., and he will not find himself in a very good legal posture there. He really doesn't have any basis, and the control over the police is strictly reserved to the state under the 10th Amendment. That's core 10th Amendment doctrine. I think that's something that any federal judge would reject very quickly. Now, as far as federalization of the National Guard in any other state, he will be in a similar posture to California, which is why this California trial is so important. It will teach judges what Judge Breyer is going through right now, and the evidence that Judge Breyer is sifting through will be extremely instructive for federal judges in other jurisdictions as they inevitably weigh posse comitatus issues in potentially the state of New York or the state of Illinois. I think we're going to find this situation replicated, and clarity about the boundaries set by posse comitatus and what federal troops are permitted to do and not do will be extremely important in the coming weeks.
I'm sure we'll be talking again. Thanks so much, Claire. That's Professor Claire Finkelstein of the University of Pennsylvania. Coming up next, a win for the administration as a federal circuit court allows it to block billions of dollars in foreign aid. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
Attorney General Pam Bondi has frequently chastised federal judges who've held back President Trump's agenda, calling them liberal, activist, and out of control.
Judges have used these injunctions to block virtually all of President Trump's policies. To put this in perspective, there are 94 federal judicial districts. 5 of those districts throughout this country held 35 of the nationwide injunctions. Think about that. 94 districts, and 35 out of the 40 opinions with nationwide injunctions came from 5 liberal districts in this country.
One of those so-called liberal districts where nationwide injunctions have been issued is the District of Maryland. And the Justice Department has picked that district to file an unprecedented lawsuit against all the federal judges in the district. It's over a standing order that blocks for 2 days the deportations of detained immigrants who file habeas petitions. Of course, Maryland is also the district that drew national attention in the case of Kilmer Abrego Garcia, who was wrongfully deported to El Salvador. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. Hal, this lawsuit is unprecedented. How much is this a ratcheting up of the Trump administration's power struggle with the judiciary?
The Department of Justice had options here. They could have easily chosen one of the 12 cases in which the automatic stay had been imposed to file an appeal, and they would have been able to obtain in an orderly fashion appellate review of the propriety of the District of Maryland standing order, which imposed the automatic stay in an immigration habeas context. They chose not to do that. They ratcheted up the tension by filing an unparalleled lawsuit against all members of the District of Maryland individually as judges. And that sets the framework for a very important separation of powers challenge, namely whether the executive branch can sue judges, get information about them, depositions, because they don't like a standing order. So the procedural posture itself is what is the most troubling aspect of this case. Not the only one, but certainly the most troubling.
The government says that 2-day pause in deportations inhibits the president's ability to enforce federal immigration laws and that the chief judge has no authority to issue such a blanket order.
Yeah, so many courts of appeals, and in the case, I think they cited 5 courts of appeals, have automatic stays in certain contexts in order to preserve the jurisdiction of the court. And so the District of Maryland is the site which famously gave rise to the Kilmer Abrego Garcia case, where the government shipped Garcia out of the country surreptitiously while a challenge was going on. And so because they had been burned and the Department of Justice had interfered with the jurisdiction of the court previously, that's what led to this standing order being promulgated. So, I mean, the Department of Justice is right in the sense that an automatic stay does interfere with cases in which the individual has no claim whatsoever not to be deported. But, you know, the delay is only for 2 days. And given what's happened before in terms of the due process violation that the government has committed by transporting Garcia and others away without any kind of chance for hearing, the court followed the lead of other courts of appeals which said, look, just give us 2 days to see if there's any substance here. And if there's no substance, we'll say, go ahead, ship the person out. So the Department of Justice has taken a very unusual stance in this context to, again, increase the pressure on judges by suing them, which is unparalleled. And in the hearing, the Trump appointee seemed very dubious as to the validity of the Department of Justice's challenge.
And Judge Thomas Cullen normally sits in Roanoke, Virginia, but the Fourth Circuit assigned him to hear this case because all the federal judges in Maryland were being sued and so were conflicted out. So Judge Cullen, a Trump appointee, told the government lawyer, one of the things about me is I don't have a very good poker face, and I think you've probably picked up on the fact that I have some skepticism. He had a lot of skepticism if you look at what happened at the hearing. He also questioned whether this could lead to other executive branch litigation against federal benches all the way up to the Supreme Court.
Yeah, I mean, we don't want the specter of DOJ suing judges and having other judges then sitting to judge the lawsuit against judges, and that comes with, subpoenas, depositions, discovery. Not only is it unseemly, it would certainly chill independent judging. So the very fact of rummaging around in a judge's files to determine what lay behind, in this case, the standing order, what kind of correspondence there was, would inhibit judicial freedom and really compromise the independence of the judiciary as we know it. So I think that Judge Cullen was right on in saying that even if there were some kind of issue on the merits here, and that there's something of a case that the Department of Justice has, this is not the way to challenge it. Take it normally and challenge it up to the Fourth Circuit, and if you need to, the Supreme Court. Don't sue the judges themselves.
This illustrates the Trump administration's offensive against the federal judiciary. There's the inflammatory rhetoric, allegations that the administration has ignored court orders, and they filed ethics complaints against 2 federal judges for things that they said in the courtroom. What's the administration's strategy?
Certainly part of the rationale of the Trump administration is to receive a softer reception in the courts. So the theory, I guess, is that if you have a broadside here and a broadside there, that judges down the road will be more receptive to their arguments, but it could backfire. This kind of action could scare even judges who would otherwise be sympathetic with the Trump administration, because if we want to have any kind of independent judging left in this country, we can't have the executive branch suing and deposing and seeking private correspondence from judges in particular cases. So that's the specter of what we have through this lawsuit. And again, I don't think the Trump administration will achieve their ends through this means.
I want to turn now to a significant win for President Trump in his efforts to dissolve the U.S. Agency for International Development and to withhold funding from other programs. The D.C. Circuit Court of Appeals, in a split decision this week, ruled that the Trump administration can cut billions of dollars in foreign assistance funds already approved by Congress for this year. How significant is this decision?
So I think this is a huge win on several different grounds for the Trump administration. And in this case, the district court had ordered the money to be dispersed and said that Congress was clear. The president has no independent impoundment authority. He's acting in violation of the Impoundment Control Act. Therefore, the district court judge directed the administration to spend the money. In the 2-1 decision, the D.C. Court of Appeals overturned that on 2 different rationales. The first rationale, which I consider to be the broad one and more frightening, is that the court said that if you only are arguing that the president violates the statute, you don't have a cause of action. There is no power for anybody who's injured by direct presidential action based upon violation of statute that can be brought in the federal courts. This is an astounding decision of immense significance, because the argument is whether the president just stonewalls, violates a statute, ignores a statute, et cetera, that no one can sue to challenge that because the president is immune from suit. So to me, that is a very consequential, incredibly broad understanding of precedents, and would be very deleterious in terms of establishing constraints on presidential authority. The majority also used a second rationale that's much more narrow and I think has some plausibility to it. There, the court said that Congress, in creating the Impoundment Control Act, established a very sensitive procedure by which the Comptroller General, an agent of Congress, can decide to sue the president for violation of the directions from Congress. And so the court said that there was an implicit preclusion of review, that Congress wanted these kinds of impoundment controversies to be adjudicated only by the Comptroller General after consultation with Congress, not by private third parties. I think the issue may be close here, but certainly my point is that this would have a much more narrow impact upon future cases. In most of these other cases we have, the federal employee cases, the grant cases, there is no implicit alternative procedure, at least arguably, and so there would not be as much of an impact upon future litigation. But this first rationale forwarded by the court is astonishing. Again, and they've said, as shocking as it may be, that no one can sue for statutory violation by the president, that the president is simply immune from that suit because the Administrative Procedure Act doesn't waive his immunity and there's no other cause of action available to make sure that the president follows statutes.
And could this same theory of immunity be applied if the president violates other statutes?
It's one of the basic assumptions of our entire separation of powers is that the president must comply with statutes. And so this decision would, in a sense, immunize the president from suits not only about releasing foreign aid, as in this case, but in so many other contexts as well. Discharging employees, canceling grants, et cetera, et cetera. If you could sue a subordinate executive branch official, that would enable the plaintiffs to get into court. But according to the D.C. Circuit in this case, there could be no direct claim against the president, in this case himself.
So, as you mentioned, it was a 2-1 decision with judges appointed by Donald Trump and George H.W. Bush in the majority and a Biden appointee dissenting. If the challengers ask the D.C. Circuit, the entire D.C. Circuit, to reconsider the decision, judges appointed by Democrats hold the majority there. I mean, it's sad to look at this as, Democratic-appointed judges versus Republican-appointed judges, but that's the way it seems to be breaking down in many of these cases at the D.C. Circuit, including on Friday in a case okaying the dismantling of the CFPB.
Yeah, and in this case, I just find that one aspect of the majority's decision so frightening and so destructive of our constitutional order. I'm sure that the entire court, if it took up this case, would at least narrow the scope of the majority's decision. And again, going back to the case we discussed with respect to the standing order in the District of Maryland, there at least a Trump appointee, I think, will have the independence of mind, seemingly so far, to say, no, the Justice Department has gone too far. And I think that's healthy. It's healthy to have sometimes Biden judges going against Biden or against Democratic sort of positions and Republican judges doing the same. So we'll have to see what happens and plays out if the full court takes this case as a whole, and that remains to be seen.
I'll be keeping my eye on the D.C. Circuit. Thanks, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.